If municipal government is the backbone of our communities, the heart is the volunteers who keep things ticking, from fire, ambulance, and emergency management services to recreation, libraries, and senior centers. Many of our volunteers are regarded not only as role models, but also as heroes, and rightly so because of the valuable services they provide. Unfortunately, some volunteer organizations have made headlines for the wrong reasons. They've become subjects of lawsuits dealing in such areas as harassment, discrimination, safety, and violence. These are basic civil rights, and we have a no-tolerance policy against violations and violators. That's where municipal attorneys like myself come into the picture, helping elected officials and professionals deal with these important issues. Please join me as I meet with the town mayor, 2 of his volunteers, a fire chief, and head of the ambulance corps, along with his recreation director, who deals with many volunteers.
Ladies and gentlemen, I want to thank you all for coming to Town Hall this morning. As you may know, we've had incidents of wrongdoing in the workplace in many parts of the state. Such incidents are unacceptable, and I thought it would be helpful to have the municipal attorney talk to us about precautions we need to take.
Thanks, Mr. Mayor. I'm happy to be here. To begin understanding this issue, you need to know that volunteers have many of the same rights and responsibilities as governmental employees. Federal and state laws cover such important areas as discrimination, safety, violence, and harassment. To protect you, the community has a no-tolerance policy towards these violations of basic civil rights.
I really appreciate you coming to this meeting. My members are very concerned about their personal legal liability. We put our lives on the line every time we go to a fire, and we thought, as volunteers, we couldn't be sued.
My members have the same concern. When you're called out at 3 in the morning, you don't want to be thinking about legal liability.
I completely understand. While as a volunteer you enjoy many legal protections, volunteers can be sued if they violate someone's civil rights. That's a whole different area of the law. There are no immunities or exemptions in civil rights.
Isn't this covered by the insurance?
Well, as much as legally possible, but under law, insurance often cannot cover the punitive damages awarded when someone deliberately and knowingly violates someone else's civil rights. In other words, you can be held personally liable. A lot of these problems can be avoided by just using some basic common sense.
I'm confused here. When we talk about civil rights, aren't we talking about employment issues? Our organizations use volunteers. We don't have employees.
Under law, the prohibition against employment discrimination based on such factors as gender, sexual orientation, race, religion, national origin, or age also extends to volunteers in organizations that receive any support from the government or that use governmental facilities such as the ball fields. In other words, for many purposes, the law treats volunteers as employees.
So does that mean that if a recreation league rejects town funds, it doesn't have to worry about these types of lawsuits?
You'd still be subject to most of these laws anyway. The reality is that the public and the courts take civil rights very seriously. You can't just run roughshod over someone else's civil rights.
I understand that some fire companies are independent of the town because they own the firehouse.
Even then, they're subject to the civil rights laws. Further, they're not exactly independent because they're structured as charitable trusts and, under some circumstances, are still legally accountable to the town.
I don't understand. Can't volunteer organizations establish their own membership rules?
Only to a point. If a volunteer applies for membership in a volunteer organization that receives government support, he or she has almost the same rights as an applicant for a governmental job. As a condition for public support, an organization cannot be a closed club. Membership rules cannot be discriminatory based on factors such as gender, sexual orientation, race, religion, national origin, or age.
In other words, we have to take everyone who applies.
Oh, that's not what I said. You can establish membership requirements based on realistic requirements, just as if you were hiring employees to run the ambulance company. However, you must be careful to administer these requirements in a non-discriminatory way.
For example?
Well, you can't give preference to, say, the mayor's brother-in-law.
That's a relief. Now I can get him off my back.
Well, what if someone with disabilities applies for membership?
You're also subject to the Americans with Disabilities Act. If someone with disabilities applies, you have a duty to enter into a good faith discussion about reasonable accommodations, just as if the individual was applying for a job. The key is the good faith dialogue.
For many of our organizations, the issue isn't accepting members because we can't get enough volunteers. Rather, the big question is discipline.
Absolutely. This is also true with career firefighters. The point is that volunteers and employees have their same responsibilities as well as the same protections from arbitrary discipline and dismissal.
What does this mean in practical terms?
It means that members charged with violating rules must be given a fair hearing. Rules must be applied consistently. Just as in an employment situation, leaders of volunteer organizations are well advised to talk to an attorney before proceeding with major disciplinary actions.
You're right about that. Too often, petty squabbles build to a big feud, and before long, the department is tied up for years in lawsuits. Much of this can be avoided if we just slow down and let cooler heads prevail.
To shift the subject slightly, I notice in the paper that many of these suits also involve complaints that someone was harassed.
Yes, that's right. Harassment lawsuits have increased substantially because most people are no longer willing to tolerate bad behavior. At one time, someone who was the target of jokes or other intimidating conduct just had to take it. No more.
It's important that we communicate this to everyone involved in the town's organization. Under no circumstances make jokes, use nicknames, or pick on someone based on their race, religion, national origin, age, disability, gender, or sexual orientation.
Come on. There's nothing wrong with a little give and take now and then.
The problem is you never know when the line is crossed and the jokes become offensive. I thought that person didn't mind it. It's not an excuse. That's why we must insist on the policy of no tolerance.
How far does this extend? I heard recently that a fire department was sued because a few members teased a gay couple who lived next to the firehouse.
The behavior of the volunteers you're talking about was unacceptable and reflected poorly on all volunteer firefighters. But there is a valuable lesson to learn here. We not only have to be strict about harassment among people within the organization, we also have to be concerned about harassment toward the general public.
And I suppose we must also prohibit volunteers from dating each other.
Oh, sure. There goes half my ambulance squad.
There's a rule of reason here. There's nothing wrong if people want to date. However, you are right that the no tolerance policy extends to sexual harassment in volunteer organizations as well. Specifically, it refers to making unwelcome sexual advances, making remarks that are offensive, engaging in physical contact with a fellow employee or volunteer, and creating an intimidating, hostile, or offensive environment by such conduct. In judging if something is offensive, ask yourself, would you want your own family members exposed to this type of conduct?
I also noticed that many of these lawsuits in the paper complained that someone was disciplined or harassed because they blew the whistle on some alleged wrongdoing.
That's because the so-called whistleblower law is very strong. Probably the most basic protection any citizen has is the right to bring wrongdoing to the attention of the appropriate officials without fear of retaliation. As we just discussed, this is why our community's complaint procedure covers employees, volunteers, and the public.
Just who is considered a whistleblower?
Under the various laws, a whistleblower could be an employee, a volunteer, or a member of the public who complains in good faith of anything he or she perceives as improper, including discrimination, safety issues, and harassment, including sexual harassment. Specifically, that would mean disclosing or threatening to disclose anything that the individual reasonably believes is illegal. Or it could deal with providing information to an investigation into any violation of law or regulation. It could also mean objecting to or refusing to participate in any activity that the individual reasonably believes is illegal or is incompatible with a clear public policy mandate concerning the public health, safety, or welfare.
Seems to cover everyone.
Almost. To be considered as a whistleblower, the individual must actually bring the alleged wrongdoing to the attention of the proper authorities. This is why we are required to regularly communicate the complaint procedure to everyone concerned.
Can you require all complaints in writing?
No, while we can encourage that complaints be in writing, verbal complaints are sufficient under the law.
Well, what constitutes retaliation?
Certainly any official act, such as suspension, termination, or demotion, but it also includes anything that could have the effect of discouraging someone from speaking out. In one case, an individual was teased by the other members of the department after complaining about something, and the courts ruled that this teasing was considered as retaliation because the department didn't take sufficient steps to stop it.
In other words, this is another type of illegal harassment.
Exactly. Further, if you are aware of retaliation, harassment, or other violations of civil rights, you can't ignore the situation even if the victim hasn't complained yet.
What do we do if we get a complaint?
Well, first, don't go running to the person who has been accused of the wrongdoing and ask if the complaint is true. The community has an official investigation procedure. Follow the procedure and take the complaint seriously.
That makes sense. You don't want the accused person to confront the accuser. That will only make the situation worse.
Exactly.
What if the complaint is false?
If the person who made the complaint knew the complaint was false, then the person is subject to the appropriate penalties for knowingly filing a false complaint. The whistleblower law only protects people from making complaints in good faith. You can't use the whistleblower law to harass someone. That violates the other person's civil rights.
You should be aware the community has adopted the 5-part program required by law to protect employees, volunteers, and members of the public.
The courts are very specific on this. We are required to adopt a clear policy prohibiting discrimination, harassment, and other violations of civil rights, establish a complaint procedure, provide training to both supervisory and non-supervisory personnel, monitor the program for effectiveness, and communicate management's unequivocal commitment to enforce this policy. Be proactive. If you see someone heading in the wrong direction, warn them before something gets out of line, and lead by example. Be committed to the policy of no tolerance and the standards set by the courts.
Any other advice?
Yes, while much of this is common sense, if you do have any questions or concerns, please talk to me or your own attorney.
Very good advice. Well, that's it. Thanks so much for helping raise our awareness on these issues. We appreciate your time today.
Okay. Thanks, good.
You're welcome.